Okay, let us study about the constitutional bodies or the statutory bodies. Okay, it is part of the syllabus, so we need to study about them. To begin with, Election Commission of India, we need to approach 3F: the funds, the functions, and the functionaries. Yes, if you are thinking on this line, then you'll be able to articulate your answer better. Okay. What are the facts? Article 324. Yes, direct control and conduct elections. Okay, it directs, control the elections and conduct elections. Okay. Representation of Peoples Act 1950. Allocation of seats in Lok Sabha and legislative assemblies. Delimitation of the constituencies. Qualification of the voter. Manner of filling of the seats of the Rajya Sabha by union UT representatives. 51 conduct of 51 is the conduct of election of the parliament and the state legislature. Qualification and disqualification, various offences, various doubts. So I beg your pardon, sir. Here it is, Representation of Peoples Act 1951. It deals with the conduct of elections to the parliament, state legislature, qualification and disqualifications of the member of the legislative assembly and member of the parliament. Various offences, various doubts, disputes, election symbol order 1968 to allocate symbol to the independent candidates and party. Model code of conduct deals with speech, polling day, polling booth, portfolio, election manifestos, processions and general conduct. So in Mohinder Singh Gill case versus Chief Election Commission, says that Article 324 operates in area left unoccupied by legislation, and the word superintendence and direction and control as well as the conduct of all election is the broadest possible term. Okay. What are the functions? Administrative function, advisory function, and quasi-judicial functions. Okay, let us see. It determines constituency, revise electoral roll, notify dates and schedules of the election, allot election symbols, court for settle disputes related to recognition of political parties and electoral symbol, prepare roster for the publicity of policies of political party on radio and TV, advise president to disqualification, cancel polls in rigging, supervise machinery, advise the president on elections to held to the post of president rule, after president rule, register political parties. Okay, so these are the functions. So what are the positives? Of course, independence. The security of tenure service conditions cannot be varied to its disadvantage. Any other commission cannot be removed except on the recommendation of Chief Election Commission. Strong leadership, yes, Sukumar Sen, T.N. Seshan. Electioneering powers, Mohinder Singh Gill, yes. Heart of electoral democracy, yes. Electoral awareness, quasi-judicial, such as in the case of Session election symbol. Enforcer of principle of electoral morality through model code of conduct. Recognition of political parties such as Aam Aadmi Party. Institutionalization of electoral democracy in India. Okay. What are the issues? Issues with the appointment and removal, no prescribed qualifications, yes, not specified terms, not debarred from further appointment after retirement, executive role in selection, yes. Fund, it has very limited functions to acting as a supra government during elections. Role of code of conduct, yes, is very limited. Role of caste and criminality could not be stopped by the election commission. Workload is very high. Credibility is again missing because of the executive appointing the election commission does. Okay, electoral offence are often neglected. Criminalization of politics is a major issue that election commission has failed to address. Functionaries, again, social media is out of its ambit. Rely on bureaucracy for implementation of model code of conduct, which often suffer from the issue of neutrality. Okay. Talking about tribunals, 42nd Constitutional Amendment Act 1976. Yes. Based on Swaran Singh Committee, we added Article 323A and 323B. Okay. Tribunal reform, rationalization and condition of service ordinance 2021. Search cum selection committee tenure. Okay, so this is not important because it was actually this amendment was nullified, was declared null and void by the judiciary. CAT almost about 27 of only about 27 of 64 seats are vacant. Yes. L. Chandrakumar case 1997, that National Tribunal Commission under Minister of Law and Justice. Yes. 232 Law Commission has said that it has a limited executive role in tribunal appointment. Okay. National Human Rights Commission, Protection of Human Rights Act 1993, in spirit of Paris Principle, Section 2 of Act defines it as a right to life, equality and dignity. Okay. Uh, what are the functions? The violation of human rights by public servant can take a suo moto. Yes. Intervene in any proceedings involving allegations of the violations of the human rights pending before the court. Visit jail and determine the detention places. Review the constitutional and other legal safeguards for human rights. Review factors including acts of terrorism. Study treaties and other international instruments of human rights. Research on the field of human rights. Spread human rights literacy. Encourage efforts of NGO and other actions. Okay, so these are the things of National Human Rights Commission. Examples, some of the good examples, such as right of Chakma in 1998 was ensured by National Human Rights Commission, argued against their deportation, took suo moto in Gujarat rights to shift case outside Gujarat. Okay, regulate own procedure, power of civil court, can call for report from the union or state, own nucleus of investigating staff. It is empowered to utilize the service of other investigative agencies. Establish effective operation with NGOs. Table report in the parliament with reasons for non-compliance and action taken report. Disposed almost 70 lakh cases and ensured compensation worth 1 billion rupees to be compensated. Okay. It has helped to introduce the concept of open jail. Yes, step towards reformative justice. Recourse in custodial death. Directive of reporting custodial death in 24 hours. Yes, so these are the positives. What are the negatives of National Human Rights Commission? That it cannot actually inquire into the cases that has happened 1 year before it. Okay. After 1 year, no power to punish violator, nor can award relied into relief, including monetary relief. Okay. Recommendatory nature, non-binding to the government, limited jurisdiction in human rights violation by armed forces. Okay, so those are the negatives. Again, Central Information Commission, it receives, inquire into the complaints, suo moto power, yes, power of civil court, all public records be given, power to secure compliance from public authority, yes, submit annual report to the government, recommend steps to the public authority to comply with the act. So this is about Central Information Commission. Central Vigilance Commission Act 2003, it inquires the corruption in the public service, exercise superintendence over CBI for the matter under the Prevention of Corruption Act. Okay, exercise superintendence over CBI for the matter under the Prevention of Corruption Act 1988, give direction to CBI, superintendence over vigilance administration and ministries, consult CVC on making rules and regulations governing vigilance and disciplinary matter, it also acts under Prevention of Money Laundering Act 2002. What are the issues? Overwhelming dependence on CBI, yes, no independence power of prosecution, delay in sanction of prosecution, CVC can only review. Government does not comply for the reconsideration of disciplinary action, such as in the case of BSNL. Poor engagement with civil society, there is a large scale vacancy, and frivolous and anonymous complaints are not allowed in the CBC. CBI is an executive body which derives its power from Delhi Special Police Establishment Act 1946. It deals with corruption, bribery, I beg your pardon, this should be 1949. Corruption, bribery, misconduct, serious crime, financial, fiscal and economic laws, taking up on the request of state, cases of public importance, special crimes under Indian Penal Code, suo moto cases in UTs, maintain crime statistics and dissemination of criminal information are the tasks, the functions of CBI. How good or how bad they are doing it, let us see. Well, the conviction rate of cases taken by CBI is almost at 65 to 70%, which is one of the best. Okay, so you cannot blame. Often, what are the negatives? It is exempted from RTI, number one. Number two, there are political misuse, caged parrot. Uh, Again, it is used for political vendettas. Okay, it suffers from the issue of general consent. Okay, so you can write these negative points. It is not that tough, so that is why it is not there here. So those points you can make it by yourself. What is the way forward? As the CGA has said that there should be an umbrella organization that to bring all the investigative agencies. Second, ARC has recommended a CBI Act. Okay. If CBI, here, this way you can conclude that if CBI is to tread the path of virtue, it should have a strong leader with distinct belief in the law and ethics. Okay, so you can conclude with this. Okay, special officer on linguistic minority. Sometimes they have been asking very static questions. You just need to know some facts. Okay. The 7th Constitutional Amendment Act brought in 1956 brought Article 350B in part. It is headquartered in Allahabad. Okay, so nothing much. Yes, okay. Talking about any commission, you can actually National Commission for Minority, OBC, ST. Yes, you can use this abbreviation MCP Pro. That is monitor, compliant, plan, prepare report, recommend and other matters. Okay, monitor, compliant, plan, prepare reports, recommend and other matters. Okay, so this is the functions of any commissions. Okay, National Commission for ST, SC, OBC. Okay, National Commission for ST is in 338, SC is in 338A and OBC is in 338B. Okay. What are the issues? Recommendations are not binding. It is a toothless tiger. Appointment post fact. Okay. Like it is usually an appointment is based on political compliance, political parties, capacity and role is limited, staff and financial crunches are also there. Okay, these are some generic issues. You can write some specific issues if you know. Okay. Finance Commission is under Article 280. Quasi-judicial, yes. Center state, yes. Principles that should govern the grant and aid of the state by the center. Okay. Measure to argument. Okay, let me see what is it. It's a quasi-judicial principle that should grant the aid of the state with center. Okay. Principle then other matters. Okay. These are the functions of Finance Commission. And nothing much. What are the issues? That this Finance Commission is not permanent body, qualification is not categorically spoken about. Then, what do we say? It is say that term of reference state is not being asked or not consulted for formulating terms of references. So you can write the certain generic ones. Okay, so nothing much to specify. Okay, CAG 148, it is a guardian of public purse. It focuses on 3E, that is efficiency, effectiveness and economy of the government expenditure. Dr. B.R. Ambedkar has said that it is the most important constitutional office as it is the guardian of the public purse. Okay, the 3 types of audit are being done. Okay, there are 3 types of audit. The first is the compliance audit. Okay, the second is the financial audit, and the third is the performance audit. Okay, let us see. The compliance audit is the budgeted and applied. What is the budgeted amount and how much is applied? The financial audit is the proper books of accounts are maintained and represented the actual transactions. Okay, performance audit correlates the financial targets with the physical target. Okay, and there is an efficiency audit. Okay, which is also there, but which is about PSC, public sector enterprises related. And then there is a proprietary audit, which is the most important audit. It questions the wisdom, faithfulness and the economy behind the financial decision, which is the most subjective one. Okay, independence, the security of the tenure, not eligible for the reappointment. Yes, salary and other service conditions are determined by the president. Okay, what are the functions? It audits the accounts related to all expenditure from Consulate Fund of India, all expenditure from Contingency Fund of India, audit all trading, manufacturing, profit and loss account, balance sheets, and other subsidiary accounts kept by the department, audit rules and procedures that are designed to secure effective checks and assessment, collection, proper allocation of revenue, audit government companies, semi-finance authorities, audit all transactions of the central and the state government relating to debt, sinking fund, deposits, advances, suspends commune accounts and remittance businesses. Any account as president or governor request. Advise president prescription to form in which account of center and state shall be kept. Submit audit report to the president. Ascertain and certify net proceeds of any tax or duty. Act guide to the public account committee. Okay, so these are the functions. CAB submits 3 reports. The first is the audit report on appropriation account. Compare actual expenditure with the expenditure sanctioned by the parliament. Okay, compare the actual expenditure with the expenditure sanctioned by the parliament. The other is the finance account, which is the annual receipt and disbursement of the union, and the third is the public undertaking. Okay, so these are the 3 reports. Okay, the appropriation, the finance, and the public undertaking. What are the role? It acts as the guardian of the public purse, financial administration, accountability of the executive and financial sphere, propriety audit, which is very discretionary, looks into the wisdom, faithfulness of the economy. It acts as a friend, philosopher, and guide to the pack. Unearth wholesale corruption such as 2G scam, coal scam, yes, Bihar fodder scam, Reliance Industries to pay 7,000 crore fine for KG basin gas project. Okay, it acts also as a watchdog. Okay, what are the issues? Inheritance from the colonial area, delay in laying a report. Yes, okay, let us see. Limited auditing power, fulfilling the role of Auditor General only, while control is a propriety audit which is not being done. Okay, in UK, no finance issued without CAG's approval. Okay, whereas in India it is a post facto audit. Okay, Secret Service expenditure cannot be audited, which is a difficult thing. Auditing government company is limited. Yes, reluctance on executive to provide data, delay. The PPP project contracts, almost 60% projects are beyond CAG's purview. Okay, extra constitutional bodies such as PM Care are again out of CAG's purview. What are the institutional challenges? And lack of knowledge about administration. Yes, appointment as per second bipartition multi-membered body. Amitabh Mukhopadhyay Bokari thinking public institution in India said that they should consult back. So these are the recommendations or the way forward for this. Okay, lack capacity for performance audit. Yes, poor quality of audit. Almost 50% of the CAG's report are not supported by enough evidences. Okay, which is this was a report by International Organization of Supreme Auditing Institution that say that this. Again, propriety audit, insight bias and invasive audit. Okay, negative effect on administration. Yes, reluctant to take decision out of fear of 4C. 4C are court, CAG, CVC, and CBI. So these are the 4Cs. Okay. Way forward, former deputy CAG BP Mathur says that re-engineering CAG calls for, like we mentioned in the above passage. Okay, so you can write these things. Talking about Attorney General, Article 76, give advice to the government on legal matter, perform other duties which President assign, discharge functions conferred on him by the Constitution, appears on behalf of government in all the cases of Supreme Court, represent government in any reference made by the President to Supreme Court, to appear in any High Court. Okay, so these are the things. Rights and limitations, right to audience in all courts, right to speak and take part in proceedings of the both houses. Yes, enjoy privilege and immunities that are available to MPs. What are the limitations? Not advise against government, not advise in the cases against the government, not defend accused person in criminal prosecution without the permission of government, not accept appointment as director in any company or corporation without the permission of Government of India. Okay, talking about GST Tax Council, Article 101, Constitutional Amendment Act 2016, 279A empowers President to constitute GST Council by an order. Functions include taxes, cesses, and such as levied by the center, state, and local body that should be merged in GST. GST goods and services that may be subjected to GST and exempted from GST. Model GST law, principle of levy apportionment of GST levy on supply in the course of interstate trade, commerce, and principle that governs the subject of supply. Threshold limit for turnover below which goods and services may be exempted from GST. Any special rate or rates for specified period to raise additional resource during any national calamity or disaster. Special power provision with respect to the state of Northeast and Himalayan states. Okay. Any other matter relating to GST or as council will decide. Okay. Other functions include petroleum and crude natural gas, high-speed diesels to be included in GST. That should decide. Mechanism to adjudicate upon disputes of center state, center state, and the other state. Okay. A recommendation of compensation for the loss of revenue by the states. National Commission for ST. What are the additional functions of this commission? Offering ownership right to the in respect to minor forest produce, right over mineral resources, water resources, relief and rehabilitation, prevent alienation, project forest and social forestry, eliminate the practice of shifting cultivation, implement PESA Act. Okay, yes. Lokpal and Lokayukt Act 2013, classification of property, power of superintendence of CBI, clear timeline, yes, special court, yes, power to grant sanction for the prosecution of public service, donation about 10 lakh in Fakra under Lokpal, and also the jurisdiction over Prime Minister. What are the issues? To begin with, it does not have no suo motu powers. Emphasis on the form of complaint rather than the substance. Heavy punishment for false and frivolous complaint. Yes. Anonymous complaints are not allowed. Legal assistance to public service. Once again, I was out of my mind, so let me do it once again. For issue. No suo motu power. Emphasis on the form of complaint rather than substance. Heavy punishment for false and frivolous complaint. Anonymous complaints are not allowed. Legal assistance to public servant, okay, is limited. Limitation period for 7 years to file complaint. Very non-transparent procedure for PM. No protection to the whistleblowers. Judiciary is not subjected to Lokpal jurisdiction. And there is an issue with the regional language. Okay. Lokayukta, Gujarat has Lokayukta from 1986, appointed by the governor. It has the Chief Justice of High Court plus leader of opposition. Okay. Judicial qualification, yes, 5 years or 65. 5 years or 65, whichever is earlier. Not eligible for the reappointment, yes. Okay, so most of the things are very similar. I still will read it. Chief Minister included, civil servants included, MLA included, local bodies, corruption, companies, corporations, companies, societies included. Suo motu, yes, can only investigate allegations of corruption, not grievances. So that is the maladministration. Annual report to governor. Lokayukta is responsible to state legislative assembly. Calls for learned files and documents. Recommendation only advisory and not binding. Okay, so yes. Now let us see into the electoral system. Many of the questions have already been periodically been asked from this section. So let us look into it. Okay, election law. First of all, part 15 includes the Election Commission of India, Article 324 and 329 to 329. Okay. Article 327 speaks that in the Constitution, and empowered parliament to make law to the regulation of electoral process. So parliament has made law. The first is Representation of People's Act 1950 and 1951, Delimitation Commission Act 1952, President and Vice President Election Act 1952, Symbol Reservation and Allotment Order 1968. Okay. Talking about Representation of People's Act 1950, Article 81 and 170. Max age speaks for maximum seat in Lok Sabha, Rajya Sabha, State Legislative Assembly, but actual number by law. Okay. So allocation of seats, registration of electoral, preparation of electoral roll, qualification of voters, procedure for delimitation of the constituencies, seat filling in Rajya Sabha, bearing court jurisdiction, local authorities for the purpose of election. So everything that is required before an election to take place. For election to take place, like what are the prerequisites? What is something that is required? So these are pre-requirements. It is taken into consideration in this RPA Act 1950. One such as the delimitation of the constituency. We will look in the look on this on that in further details. Delimitation Commission. The Constitution under Article 82 empowers Parliament to enact a delimitation act, and based on that act, delimitation commission is formed with a distinct term of references. It demarcates the boundaries and present to the president, and Parliament then approves it. Okay. Constitutional Amendment Act 84th has freezed the delimitation procedure until 2026, and 87 Constitutional Amendment Act internal delimitation based on 2001. Okay. President of India has been conferred with the power to amend the order of delimitation constituencies only after consulting Election Commission of India. Okay. Election Commission of India, power to determine the constituencies to be reserved for the scheduled tribes in the state of Meghalaya, Mizoram, Nagaland and Tripura. Okay. The wives of such person are also deemed to be ordinarily residing in India. There is a proposal of making some provision for gender neutral by replacing the term wife with the spouse. Okay, so in order to this, the civil courts have been barred from questioning the legality of any action of electoral returning officer regarding revision of electoral rolls. Okay, so these are the two things which needs to be amended. Okay. Representation of People's Act 1951, qualification and disqualification of members, notification of general election, administrative machineries for the conduct of election, registration of political party, conduct of election, disputes regarding election, corrupt practices and electoral offences, free supply of certain material to candidates of recognized political parties, by-election, power of election commission to inquire and disqualify. Okay. What are the qualifications? Person must be elected to the constituency. Person must be a member of scheduled caste or scheduled tribes in any where she is contesting the seat and is served. Minimum age 25, Panchayat 21. Okay. Disqualification RPA Act, found guilty of election offences or corrupt practices of Section 123, imprisonment of 2 years or more, Section 8, fail to lodge accounts of election expenses within time, not have interest in government contracts, work or services, not be director or managing agent, nor hold office of profit in corporation in which government has 25% share, not have dismissed from government services for government corruption, must not have convicted of promoting enmity between different groups or offences of bribery, not have been punished for preaching or practicing social crime. Okay, so these are the disqualification based criteria under RPA Act. Constitution, office of profit, insolvent, unsound mind. Okay, so the 3 and law of the parliament. So, law of the parliament is this. Okay. What is significance? It helps direct democracy, equal representation, yes. Delimitation, which brings equality in the process of election, yes. Federalism, due to representation of each state in the parliament. Decriminalization of Indian politics can be a possibility. Accountability and transparency, expenditure monitoring mechanism. Clean election prohibits corrupt practices. Encourage political liberalization and democratization, yes. Legible political funding through electoral bond and right to information, yes. Okay. What are the challenges? First is the false disclosure, the bureaucratization of politics dependent on union for financial matters and electoral staff, dual responsibility of Election Commission of India. Election Commission of India does not have an independent staff, misuse of government machinery. The RPAs lack clear provisions and guidelines, unfair advantage to the ruling party. Act allowed those serving sentences less than 2 years to contest elections from prison. City expenditure is very less, 70 lakh and 20 lakh for Lok Sabha and state legislative assembly is very low. The Election Commission of India cannot de-recognize the party. No obligation of the company to report such donations to its profit and loss account. Foreign influence, yes. Political parties accept contribution from foreign companies defined under FACRA 2010. What could be the way forward? Restriction on opinion poll, yes. False declaration as an offence. Independent Election Commission of India expenditure should be charged on the consolidated fund of India. Delisting of valid electorate made offence. State funding of election. Other card, election card linkage. Okay. Okay. Again, section 33 clause 7, which of the RPA Act, I think 1951, allows for the candidate to fight from the two seats. Okay. Okay. Electoral reforms. Why do we need in the first place? Okay. First is new challenge of social media, voter awareness, the caste-based politics, criminalization, intra-party democracy is lagging, EVM and VVP, Nota, paid news, model code of conduct. Okay, so because of which there is a need for electoral reforms. Electoral bond, RTI, funding, Anti-Defection Act, election powers and manifesto. These are the various issues. Simultaneous election is a perennial issue of election, so there could be a potential question on it. The structuring of Indian election cycle in a manner that are in sync under which voter can cast vote on the same day. 79th Law Commission and the Parliamentary Standing Committee has favored the simultaneous elections. Okay. Focus on administration. Regional issues will not get submerged. Yes. Reduce logistical cost of conducting election. Policy paralysis will reduce expenditure on election campaign, integration and unity. Okay. What are the issues of against Article 83 and 172 dissolved earlier? Manpower, regional issues, suppression, cyclic accountability, anti-defection law, precedent to reduce state autonomy. Okay. So here you can actually quote that the government has been moving the needle by establishing Ramnath Kovind Committee. Okay. Electoral funding. ADR has said that almost 75% of the party funding in the past 10 years have come from unknown sources. Okay. Center for Media Studies 2019, the most expensive, 100 crore per constituency. Okay. Electoral bond. What are the issues? It is against the concept of one vote, one value. Shell companies favor a ruling party. Yes. Electoral trust using electoral bond route to bypass disclosure. Okay. Party system in India, Section 29 of the Representation of Peoples Act 1951, it submits memorandum stating that it shall bear true faith and allegiance to the Constitution of India as by the law established. What are the advantages? Increases the electoral participation, multiple options to choose, dictatorship is prevented, opposition of regional parties to participate in national politics. Okay. What are the disadvantages? hung assembly, unstable coalition, ideology-less alliances, decision-making may be delayed, impact of foreign policies, stealth reforms. And, okay. Model code of conduct, it is an important topic to understand. Set of norms for the conduct of behavior of the part of the parties and the candidates. Okay. Need develop level playing field, campaign fair and healthy, avoid clashes, peace and order. Ruling party does not misuse the power. What are the legal status? Yes, should be given. No legal vacuum for election commission of India. Most of the provisions have legal backing. Okay, no, because codification of conduct and of administration works. Court litigation will increase. Difficult to codify ethical norms. Okay, so these are the issues. We need to also discuss various issues of current nature. Such first is the appointment provisions of Election Commission of India. Second is the Women Reservation Bill. Okay. Third is again the third would be something that we'll know about them. Okay. So yes, so, the current news is needs to be discussed, and some of the portions of the Gujarat is also been pending. So we'll do that collectively in the subsequent lectures. So thank you very much.